812.
No.
Okay.
Give them
812
812
6199
6199
2671.
2671. Yes, meeting.
Okay.
Yeah.
926
926
287.
287.
Yes, sir.
Join meeting?
Yes,
Or
sir.
is it with early? Okay, I'll do it.
Yeah, you can join us. We can get you in. So you have to copy the meeting.
Okay.
Volume?
Yeah, just the volume was too loud.
Okay. Where am I now? Zoom. Oh, shucks. Have I got myself off? No, I haven't. Here you go. Full screen. Start. Okay, you put that on one side. So, how's the sound? I mean, can they hear me? Can you hear me? Can you?
There's nobody there yet.
But when it's being recorded.
Yes.
Yes, good morning. This is Wednesday. Yep.
So leave this on.
Yeah, leave that down.
Okay.
Chief's gonna have his volume up on that one.
Okay.
Otherwise, he's gonna hear his own voice.
Right.
Chief, just to be mindful, this connection, the clip is broken. I have to replace the cable.
Okay.
So if there's too much movement on here, it will come out.
I will not
Yeah,
touch it.
yeah.
I will not touch it. Okay.
All right.
Yep. I mean, I don't propose to touch the screen at all, really.
Okay. Okay. Thanks, Brian. Just finish and sending the link and then we can start you. So we have just waiting for, looks like Griffith or Pettingill.
Mhm.
We have Mr. Duncan, we have Ms. Finnegan, and Mr. Howard from AGA. But no one from.
Does Mr. Griffiths have the new numbers?
Yes, I sent it to Mr. Pettingill and his assistant, Ms. Anderson.
Okay.
I sent it twice just to just to be sure. I'm just gonna go grab your water in the meantime. installing stuff now. Transfer ko. Did you want to get the rest of what they put or start?
Start.
Okay.
Yes. Good morning.
Morning, my lord.
Can you hear me now?
I can hear you, my lord. Yes.
As can I.
In that case, I just have to make sure that I can ask Brian to. I think the only person we're missing is Mr. Griffiths. Is he joining us, Mr. Pattingill?
Yes, my lord. Yes. And I don't know if you received the most recent details that just went around with on
Yes.
45, but as far as I know,
Yes. Perhaps you can call
Brian?
him, Mr. Pattingill, to make sure that he has the numbers.
I will, my
Thank
lord.
you.
Sorry, good morning, my lord. I just wanted to clarify, I'm on someone else's computer, so you'll see it's a different name. But I just wanted to
Yes,
clarify it is Chambers.
No, I understand Mr. Howard is no longer with you.
Yes,
Or he's
yes,
retiring.
yes. Thank you.
Morning, Miss Still, Francois.
Morning.
I have chased him, my lord.
Yes.
I just got a message that he just got the Zoom link. He'll be momentarily.
Yes.
He's on his way. Is it still doing it?
We'll see.
Okay, he's here.
Yeah. It's Wednesday, the 7th day of July, 2021 at 9:37 a.m. before the Honorable Chief Justice, Civil Jurisdiction 2021, number 162. Albert Brewster and others, and the Premier of Bermuda and others. Mr. Griffiths, QC for the plaintiff, and Mr. Duncan, QC for the respondents.
Lord, I should just say that I appear with Mr. Hawthorne for the record.
Yes, and of course, Mr. Pettingill appears for the plaintiffs.
Thank you.
I can't see Mr. Griffiths.
He doesn't seem to have his mic on.
Perhaps he should turn his video on.
One moment. Hello?
Yes, Mr. Griffiths, we are waiting for you.
Can you hear me, my lord?
I can hear you, but I can't see you. If you see a video marker, you should click on it.
Finally found it. Can you see me?
Yes, I can. Good morning, everyone, and welcome, Mr. Griffiths. Perhaps I can just indicate how we are going to deal with this matter in terms of sitting times. We will sit till 11 o'clock and then we will take a 10-minute break. And then we will continue until 1 o'clock. And then we'll take a short adjournment till 2:15. At 3:30, we will take another 10-minute break. And we will continue until 5 o'clock. And if necessary, and as necessary, we'll repeat the same process tomorrow. So that's the schedule. And in terms of just presentation, unless you are addressing the court, it would be advisable to turn off the video and the volume. On that basis, in terms of starting these proceedings, the first application I should deal with is, which I see that is not contested, is the application to admit the evidence which was filed one working day late. Can we deal with that first, if that's acceptable to everyone?
Yeah.
Yes. Well, I mean, I've seen the summons. I've seen the affidavit which is filed in support of it by Aideen Rattree-Price. I have read the note by Mr. Griffiths, and whilst he makes certain points in relation to the weight and so on, it's not formally objected. And in those circumstances, can we work on the basis that the affidavits which have been filed are admitted in evidence, and you can make whatever submissions you want to make in relation to their weight and relevance and the like. Is that acceptable to you, Mr. Griffiths?
Yes, it is, my lord.
Yes. Well, on that basis, the evidence is admitted, and then it's for you to commence, Mr. Griffiths.
My lord, I appear on behalf of the three applicants with a learned friend, Mr. Mark Pettingill, and also Aaron Hill, counsel.
Yes.
Now, the starting point from our point of view, my lord, is this. Yesterday afternoon, so on the 6th of July 2021, the applicants were served with 23 authorities, which the respondents rely upon in respect of its submissions. Having now reviewed that wealth of material in the short time scale available, in our submission, these supplemental submissions are being now added to your lordship. as a key memoir to the key submissions we have made, and which will be advanced on behalf of the applicants to address the submissions on authorities relied upon by the respondents. Now, it's patently clear in our submission, from now having read the submissions put forward by the respondents, that they are advancing a case strategy which we bluntly assert is designed to obfuscate the core issue which in our submission the court has to determine in these proceedings. It is equally clear to us that the respondents have this case strategy because they simply do not have an evidentiary basis upon which to discharge their burden of proving inter alia that the mandatory 14-day hotel quarantine is reasonably required, justifiable, and cannot be achieved by less intrusive means. Thus, by way of example, yesterday evening, the Honorable Kim Wilson, who is, as your Lordship knows, the Minister of Health, discharged certain information which has not been quoted by the respondents or relied upon at any stage. And we bear this in mind because the respondents assert at paragraph 7 of their submissions that, to quote, as at the date of the hearing, less than 60% of the Bermuda population is fully vaccinated. More than 40% of the Bermuda population is unvaccinated. And they further assert at paragraph 8C of their submissions that there are 19 active cases. Now, the nature and type of information contained in the second respondent's press release yesterday evening is missing from her affidavit, already served upon the court in these proceedings. And it is important in our submission to start with an examination of what was publicly stated by the health minister yesterday evening. The starting point is this: Bermuda's most recent COVID-19 test positively rates, as at the date of this hearing, 0.1%. Secondly, the 7-day average of Bermuda's real-time reproduction number is less than 1. Furthermore, Bermuda's current WHO, World Health Organization country status is, and I quote, sporadic cases. In this country, 2,473 people have recovered from COVID-19 out of a total of 2,500 521 confirmed cases. Now, the applicants contend that the information contained in the second respondent press release last evening is highly relevant insofar as it clearly illustrates in our submission that Bermuda's COVID-19 situation is not one which requires measures as extreme, as coercive, and as unreasonable as the mandatory 14-day hotel quarantine.
Yes.
And we say that for this reason, because the second respondent's press release yesterday evening confirms that the foregoing references in the respondent's submissions are inaccurate. The second respondent's press release confirmed, firstly, to date, 64.9% of the total population in Bermuda has been vaccinated with one dose. Furthermore, 63.2% of the population.
What was the percentage again?
The initial one I mentioned, Malou, was that 64.9%
yes,
of the total population has been vaccinated with one dose. Furthermore, 62.2% of the population has been immunized with 2 doses.
yes.
Currently, there are only 15 active cases of COVID-19 in Bermuda. So at the date of this hearing, and remember, I've extracted these details from what the health minister said yesterday evening.
It's in the newspaper this morning.
I'm grateful.
Yes.
But it's important in our submission because there are no individuals in Bermuda's hospital suffering from COVID-19 at the moment. It follows that the number is 0. Now, according to that press conference, at the time of this hearing, 63.2% of the population have received both doses of the vaccine. And are categorized, as I've mentioned, as immunized. And so we consider this to be somewhat important. And at one level, contradictive of some of the evidential propositions upon which the respondents are seeking to rely. Because examining it further, 80% of those individuals aged between 65 and 79 have had 1 or 2 doses. So at present, we submit that the seriousness and the requirements suggested in the regulation being put forward by the respondents is questionable. Because in effect, the respondents are seeking to shut out the applicant's ability to seek judicial relief of a measure which clearly engages inter alia the constitutional right to freedom of movement by advancing, in our submission, the breathtakingly patronizing suggestion that the applicants, 2 Bermudan fathers and 1 Bermudan mother, all of them have, as is submitted, Bermudan children whom they love and care for overseas, are pursuing a trivial constitutional claim by challenging a measure that affects their ability to travel to see their Bermudian children overseas, and or means that they will be liable to pay the high costs of the mandatory 14-day quarantine, which they cannot afford. So in our submission, the applicant's Section 11 right is being contravened because of the mandatory 14-day quarantine. The applicants who have Bermudan children overseas, who they ordinarily arrange to visit, are not able to travel to see their children, nor are they able to bring their children home unless they consent to be subjected to the mandatory 14-day hotel quarantine with the costs that will involve. And in our submission, that restricts the applicant's movement on account of their decision to refrain from, at least for the moment, receiving a treatment which has not received FDA approval, that is Food and Drug Administration approval, and which is not mandated by the law. And in our submission, it's trivial for the respondents to suggest that in order to gain locus pursuant to Section 11 of the Constitution, the applicants must book a ticket. Why? They are parents with children overseas, and they have not made travel plans because they cannot, in light of their knowledge that by doing so, they will have to be subject to the mandatory 14-day quarantine, which they cannot afford, and which would cause them, among other things, unreasonable emotional distress on account of their decision to refrain from, at least for now, receiving a treatment that has not yet received FDA approval, and as I say, which is not mandated by the law currently. And going further in this submission, we note that amongst the 23 authorities sent to us, I think it was yesterday, or shortly
In all
before.
fairness, Mr. Griffiths, the relevant ones were actually cited at the injunction hearing. So
Well,
I
if-
think Mr. Pettingill would have studied them.
Well, he'll have a better refrain than I will, because despite being engaged in other proceedings in the Cayman Islands where I am now, I had to consider those 23 authorities in the last, well, day or so. but I make mention of them for this reason. I know that amongst the authorities relied upon is Benavides and others against the Attorney General, a case which concerned the interpretation of the wording of the Trade Unions Act 1965, and whether that wording was void for inconsistency with Section 10 of the Constitution. And in our submission, that case is clearly distinguishable from the proceedings we are now involved in. And the factual matrix that the court was considering was completely different from the factual matrix of the current case. Why? Because the applicant's claim cannot seriously be described as trivial. In the context referred to by the court in Benavides. Now, the fact that the respondents feel that it is required for the court to review 23 authorities in order for the court to understand the thrust of their submissions is, in our view, an illustrative example of the respondents deploying their case strategy in order to obfuscate the issue, in order to distract from the respondents' evidential inability to demonstrate by way of evidence relevant to Bermuda and not elsewhere, like the UK, Canada, and the US.
I mean, just on that, Mr. Griffiths, it wouldn't be unusual in a constitutional challenge case to have 23 authorities. I had another constitutional challenge case.
Lord, can I just deal with one? Can I just pause for a moment?
Yeah.
Because you may hear some noise in the background, and I'm trying to sort that out.
Oh, okay.
My lord,
Yes.
my apologies for that,
No, not
because the problem I'm facing is this. The Grand Court in the Cayman Islands, Wi-Fi has broken down. So I'm having to insert our arguments from the hotel in which I'm staying here in the Cayman Islands. And unfortunately, given the time, they've put on some noise outside, which I'm trying to avoid. And I've told them to turn it down. So that's the difficulty I'm facing.
No, that's fine. We can hear you perfectly, so it's not an issue with us.
Thank you very much. And so the point I'd reached was our blunt assertion that the respondents' evidential inability to demonstrate by way of evidence relevant to Bermuda is a major difficulty, which in our view, your lordship should address. And we say that because at paragraph 28 of the respondent's submission, they assert that the legislative objective for the mandatory 14-day hotel quarantine is public health and public safety. Namely, that's paragraph 28.
Yes.
And that legislative objective, namely to control and prevent the public health and public safety, namely to control and avoid and prevent the spread of COVID-19, quarantining immunized persons at the border, who they say are at greater risk of transmitting COVID-19. The respondents then go on to state that herd, to borrow a phrase, immunity is the policy of the government of Bermuda, which is why we submit that the percentages which were publicized last night give a clear measure of the possible dangers of these kinds of concerns here in Bermuda. And the fundamental question is, to what extent does that need the regulation, which is at the heart of the position being adopted by the respondents? And so that is why we've begun with this topic, because we submit that the respondents require an answer to the extent of the problem this regulation proposed is seeking to address.
What, do you know what station the Senate is on?
Oh, it's not on 107.
I think whoever it is.
But it's an
they need to
FM
know the
station.
volume,
It's
please.
an FM station, yeah. So I got a crap radio.
Yes, yes, Mr. Griffiths.
Can your lordship hear me?
Yes, I can.
But
I can hear you. Can you hear us?
I can hear you, my lord, and I can see you now. I didn't just now. Now, my lord, the next point we make is this. The respondents proceed at paragraph 39 of the written submission to refer to an extract from the affidavit of the chief medical officer, Dr. Ayola Oyintoye, wherein he confirms that the second respondent indicated that herd immunity would be reached when 70% of the population.
Depends on what variant you're talking about. Depending upon which variant is actually predominant, it will vary. I mean, if you look at Dr. Weldon's affidavit, she points out that depending upon which one it is, it can go up and down as much as, I think, 84%.
My lord, yes. But presenting that as the region required in order to create this herd immunity, it is important in our consideration to also look at what the figures actually are now.
Yes.
As publicized yesterday. And consequently,
it's. I mean, obviously, these figures go up and down. Obviously, vaccination will continue to go up, but as far as the number of infected people and number who have recovered, they will go up and down. I mean,
Yes, it will go up and down. But if that's the current situation, we ask publicly, how does it, given the current situation, bring the immediate consideration that a further regulation should be introduced?
Well, it might be said, and you should address this, it might be said that we were in a similar position just before the last outbreak, and that resulted in 21 deaths.
My Lord, yes. But my Lord, we should also consider the rate that this has grown. Because remember, the percentages relied upon by the health minister has been reduced since the 13th of February this year until its conclusion, which is the 3rd of July. So if things are moving in that direction, one of the considerations surely has to be, what is the relevance of the new regulation at this stage if there is nothing to suggest from February until July that movement is not taking place in the direction all considerate people require? And
we had a major spike just recently. And
well,
resulted in serious dislocation of the economy. And as I said, 21 people died.
Yes, but in which direction is this reduction going? Because fundamental to the argument we put forward is this, that there has to be an evidential proof for the proposition the respondents are making. And to what extent has that evidential proof been provided by them? And we submit none whatsoever.
Yes.
And that raises, my Lord, in our submission, the question, does their current position evidentially provide the kind of burden of proof which is obviously upon their shoulders? Does it address that? And if that is not the case, there is a level at which we submit there is a crucial central issue which has to be addressed at this stage. Where is that evidence going to come from? Secondly, where is it stated, that evidential basis, in any of their submissions? And the 23 authorities served recently, to what extent do they address that evidential base? They don't. In our submission, it is a distraction from what is a very central evidential point which they must establish. And the simple question is, have they? We submit that they have not. And so consequently, there is a very short and immediate way in which the issue raised by the applicants should be addressed. And we submit it has not been addressed. No answer has been given to that fundamental question. Now, my Lord, we note, of course, and one of the reasons why we have sought to emphasize that information which derives from Bermuda, that the respondents in their affidavits have referred to other jurisdictions who have distinguished between the vaccinated and the unvaccinated. And the reference to other jurisdictions we suggest, do not assist with the assessment of whether or not the measure subject to challenge is reasonably required. Is it? And it's the second respondent who has now provided information which raises that question in a very important perspective.
Well, let me just ask you that. I mean, you say it's not relevant. I mean, they say the similar arrangement exists in Cayman where you're sitting. I mean, isn't that relevant to the court that similar jurisdictions like Bermuda, similar size, similar issues, they have implemented it? And if they have, why is that not relevant?
Well, the Cayman Islands, I appreciate, have adopted certain measures, including, quarantine.
Yes.
But remember here, the bottom line is whether people have to, in Bermuda, take the 2 vaccines, even though individually they might not want to. And if they don't, they pay a price in terms of traveling and upon returning, what it's going to cost them.
Well, I mean, as the chief medical officer tries to point out, he says that obviously everybody has a choice whether to be vaccinated or not. But if you choose not to be vaccinated, it's a choice which not only affects you, but it affects other people. It affects the community because it potentially accelerates the spread of the virus. And in those circumstances, he says the community has a legitimate interest in putting in place measures which may mitigate that risk. I mean, that's how it's put. I mean, it's obviously, in a case where you have a choice which only impacts upon you, you're entitled to do whatever you want. If you choose not to go to university because you don't think it's a sensible idea, that is your choice. It doesn't have any impact on anyone else other than, I suppose, theoretically on the society, because you lose a potentially educated person. But this is not such a choice. This is a choice which, if you choose not to be vaccinated, it not only has an impact upon you in the sense that potentially, if you are infected, there's a chance of serious health issues, but it impacts others because it increases the spread of the virus. That's the thesis. And it's for that reason they say that they are entitled to distinguish between those who are vaccinated and those who are not. And they say that the government is entitled to put in place measures which seek to mitigate the risk. And I mean, that's the real issue. It's nobody's saying that the community members don't have the choice whether to be vaccinated or not. But if you choose not to, it has certain consequences because it impacts upon others. I mean, as the chief medical officer says, he says that it has an impact upon those people who can't be vaccinated for one reason or another, because there is a potential prospect of being infected.
Yes, but my lord, is there a mandate in existence to say you must take the vaccinations?
No, I mean, there's no legal requirement for anyone to take to be vaccinated, but clearly there's a choice, but the choice has consequences. Those consequences don't simply stop with the individual. They impact upon others. They impact upon the society at large.
Yes, but I've already mentioned what the current situation is, and your lordship has already indicated that you're aware from today's publications what he said.
It's in the newspaper on page 1.
But the bottom line is this. All of those regulations are in place and have had a consequence. And the essential issue is another regulation required? And to what extent will that additional regulation, given all the things, including the bracelets, tracking bracelets and stuff, are in place and available, to what extent is this going to improve the situation? Unless, of course, you're relying upon the threat financially which this new regulation imposes if you don't take the 2 vaccines.
Well, I mean, you have the, I mean, you'll obviously make submissions on it. You have the evidence of the health minister who gives certain examples of individuals who were supposed to be quarantining at home, and they did not. I mean, she gives the example of one individual who then went to a party on day 12 and infected a number of people, which apparently led to the last spike, which potentially ended up with 21 people being dead. And that person was supposed to be quarantining at home. And she gives other examples of why it doesn't work. You have the evidence from the Premier, who says that they considered all the different options, and they specifically considered the issue of quarantining at home, and it was decided that that would not work. A, because they don't have the resources, but secondly, it doesn't have the compliance rate is not there. I mean, these are the value judgment issues which the government was faced, and they've taken a view. And the question really for us to consider is, you know, what is the correct approach for the court in those circumstances where these issues are presented to the executive body, which makes a decision, in circumstances where I fully accept there is no consensus within the entire community. It's quite clear that some people, a certain segment, including obviously your clients, take the view that it's unnecessary, and that is a generally held view. I understand that, but what is the court to do in those circumstances? I think it's important to focus on where we are. These are the judicial proceedings seeking to challenge a decision made by the government based upon a constitutional provision. And I think what we need to focus on is what approach should the court take? What is the test? Obviously, is the court being asked to substitute its own decision, or is the court seeking to review that decision by applying a certain test? And what is that test? Will the court only interfere if it can be shown that the decision is clearly wrong, as is seemed to be suggested in the Scottish minister's case, or is there some other test? And I think it is quite important to focus on what is this inquiry, the judicial inquiry, what is the appropriate test, what should the court do before looking at the facts, what is the appropriate approach?
Well, in our submission, the central question to be addressed is the bold assertion by the respondents that the data and scientific evidence demonstrate that hotel quarantine is more effective than home quarantine, which is why they've made this adjustment under the regulation. And they make that assertion despite the instructive concession contained at paragraph 6 of the affidavit, the expert report of the Dr. K. Pedden. As your lordship, I'm sure your lordship has seen it.
I've read it. I mean, clearly, the scientific opinion here is not uniform, but you're still faced with the question. The government has to take decisions, even if the consensus, there may not be uniformity of medical scientific opinion. What is the executive to do? And once the decision has been made, what is the test by which this court should look at it?
Well, the test, in our view, has to be, is there a guarantee that this regulation is going to bring an advantage to the current situation? Will people benefit as a result of that? And at present, where is the evidence to suggest that that is going to occur? And where in the submissions made by the respondent can we develop a firm conclusion that that is going to bring a major improvement? Where is the basis for that argument? Given the number of regulations already in place and the impact they've had.
Sorry, do you not think that
No
maybe
problem.
putting it too highly to say that is there a guarantee? You know, clearly in the middle of a pandemic, when the government is taking measures to prevent further spread, I mean, there can be no guarantees. I mean, it's impossible to say we've taken these measures and we can guarantee that they will be successful. The government in those circumstances, with the best information they have to take a view to decide on a course of action which they believe is likely to be positive. But there can be no guarantees. I'm just wondering whether that's the right test.
Well, isn't there need for a justification of the view taken?
Yes.
To justify that.
And you see that, for example, the case which you cite, in the Scottish minister's case. I mean, the analysis there is, they say that, following the earlier cases, the suggestion seemed to be that the court will only interfere if the court concludes that it's clearly wrong. I mean, do you accept that test?
Well, I don't think the test needs to go that far. What I suggest is the important need is for there to be some reasonable argument which justifies the adoption of this new regulation. So what is required is not a model saying this is going to improve, but some justification for saying it is important that this new regulation be brought in because we feel that it better provides for the citizens of this country. But where's the basis of that?
Well, I mean, they've tried to do that in terms of the affidavits which they've filed. I mean, you obviously clearly disagree with that, but I mean, they have set out why they have decided upon this course of action. It's in the affidavit of the Minister of Health, the Premier, the Chief Medical Officer, Dr. Weldon. I mean, they all speak with one voice as to why it is that they have decided on this course.
And my lord, it's unsurprising that they all share the same view because they're all behind the introduction of this regulation. And at one level, frankly, it's political. And that has to be borne in mind. But despite the politics, one also has to bear in mind the concern that a lot of citizens here in Bermuda have about this further step being suggested by the government. And without any public justification as to why it is thought necessary by the government at this stage.
Yes.
So just to pick up my submissions.
Yes.
Now, at paragraph 48 of their submission, the respondents refer to an extract from the second respondent's affidavit, wherein she referenced 6 examples of breaches that the respondents assert occurred. It must be noted that the court has not been provided with the date of these breaches, and the respondents have failed to proffer evidence that demonstrate that those breaches resulted in outbreaks of COVID-19. They can only assert that they believe that the breaches resulted in outbreaks. Has your lordship found it?
Yes, but I mean, it's obviously the science is not perfect in predicting, but I mean, this is the Minister of Health. The Minister of Health says under oath that a traveler returning to Bermuda was supposed to quarantine for 14 days by the rules of the first 14-day continuum. The traveler breached the quarantine requirement and attended a large party on day 12 of the quarantine. There was an outbreak at the party. The traveler reported becoming symptomatic on the evening of day 12 and attended the party and subsequently tested positive for COVID-19 on day 14. The outbreak at the party is believed to have led to the most recent and worst outbreak these islands have experienced, resulting in 21 deaths. Further, this was the first time the B117 strain UK variant was identified. I mean, why do you say that the court can't rely upon this as factual evidence if the Minister of Health is putting it forward under oath?
But, my lord, no evidence has been preferred in that regard. None whatsoever.
I mean, obviously, the minister does not want to identify the individual because of privacy reasons. But
sorry, my lord.
But I mean, it's certainly speaking for myself. I would, unless you tell me otherwise, have no reason but to accept this as evidence.
But my lord, is there not a speculative element to what is said there regarding the outbreaks and the resulting 21 lives?
Yes.
Yes, that might be factual. But in terms of how regularly that might occur and the impact it might have, particularly in light of what we now know about COVID-19 vaccination, anti-COVID-19 vaccination, merely looking at that simple factual suggestion, there is no guidance there that necessarily there's going to be a much wider outbreak unless they bring in this regulation. That's why we suggest that is speculative. And it provides no secure evidential basis for the arguments and suggestions they put forward. And furthermore, my lord,
yes,
in the penultimate paragraph 66 of the respondent's written submission, the respondents make the completely unsubstantiated averment that if the mandatory 14-day hotel quarantine is not maintained, there may be an immediate flood of unvaccinated travelers not required to quarantine. to quarantine and so able to transmit the VOCs in Bermuda. Now, first of all, we submit that the requirement to quarantine this averment, aside from being highly inflammatory and totally unsupported by evidence, and I'm dealing here with the evidence relevant to Bermuda's current COVID-19 situation. And we submit that all of the foregoing points that I've made can be developed in further oral argument if that is required. But bluntly, at this stage, in light of the current position, it would be helpful to the applicants to know, in light of that, what their actual argument is now, post what the health minister had to say yesterday evening, in terms of the evidential substance they now rely upon for the claims that they're making. And being such a direct issue, in our submission, it'd be helpful to your lordship if we could pause for a moment at this stage and have an idea what the respondents' responses to the arguments that I've put forward so far.
Well, I'm not sure what you're asking. I mean, you're asking to respond to what you just said so far.
Yes, my lord.
I think we should just proceed in the regular way. I think you should complete your submissions and then Mr. Duncan will respond. Otherwise, it'll be, unless Mr. Duncan is dying to respond at this stage to what has been said so far.
My Lord, I'm quite happy to follow your indication as to the best way.
I think, Mr. Griffiths, I think we'll follow the traditional route. You should complete your submissions, and then no doubt Mr. Duncan will then respond, and then of course you will have a full opportunity to reply.
Yeah, of course. Now, no doubt your lordship has seen our written submission.
Yes.
And your lordship has referred already to one of the authorities we have quoted in that submission.
Yes.
And the question I ask at this stage, your lordship having gone through it, is there any particular submission which you'd like us to develop at this stage?
Well, I mean, I do want both sides' assistance in relation to, I mean, you will see some of the cases cited by Mr. Duncan, which say that when this court is looking at the decision made by the executive body, which has the constitutional authority to make decisions of this sort, it's not the function of the court to substitute its own decision. There are other cases which say that, particularly in the context of pandemic, and there are cases specifically dealing with the issue which we are concerned with, the subject matter of the pandemic and this particular virus, that clearly in circumstances where the scientific evidence and the options available to the executive body are being presented to them in circumstances where the science is not perfect and there are conflicting views within the medical community, conflicting views within the scientific community as to what is the best course to take. The executive cannot take the view that they're going to take no view at all, no steps at all. They have to make a decision. The decision is made in circumstances where there is no one path. There are a number of paths, and they have to decide which path to take. And I do want your assistance that when you come to this court and say, we say that the decision which they have taken is unconstitutional because prima facie it infringes the fundamental right to freedom of movement unless it's reasonably required. With what lens do I judge that decision, bearing in mind that the decision is made in circumstances where there is no perfect science, there is no one answer. There are a number of options which the government can take, and they choose to take one. How is this court to decide that? I mean, clearly, this is not an issue where the court says, we will, in my view, if I had been taking that decision, I would have made this decision, and therefore I rule that the decision made by the executive is wrong. That clearly is not the test. All the authorities say that is not the test. And I do want your assistance as to when I'm looking at this decision taken by the executive, what's the test before I say that I conclude that it was not reasonably required? I mean, look at the case which you cite yourself. Perhaps we can look at that. If you look at your case, this is the Philip and the Scottish ministers case. The decision by Lord Braid.
Braid.
Yes, and if you look at paragraph 100.
Just give me a moment.
Paragraph 100. You see, he refers to the Bank Malat case, which
Yeah,
you also
100.
on.
Hold on, I'm coming to it now. Yes, my lord, I found it now.
Yes,
which begins, insofar as they pursue.
Yes, paragraph 100, he refers to the Bank Malat case and in the context of that regulations are proportionate. And then he says, after about the fifth line, I take from this that while margin of appreciation is still a relevant factor at several of the stages, as we will see, it's not a complete answer to a challenge that a decision or legislation is not proportionate. And then if you look at paragraph 102, he says, as Lord Reid made clear in Bank Malat, paragraph 92, rationality is a causal test. The decision maker has a margin of appreciation, but that is achieved by holding that a measure is rationally connected to its objective if implementation can reasonably be expected to contribute to achievement of that objective. Do you accept that as a test?
Yes, but the important use of the word reasonably.
Yes, reasonably be expected to contribute to its achievement.
Does that not place a burden on the respondents here to show why they claim the introduction of that regulation would be reasonable?
Yes, but the test is reasonably be expected to contribute to the achievement of that objective.
Yes.
But you accept that that is a test which the court should apply, do you?
Yes, it is.
Yes, and at paragraph if you look at paragraph 106, you'll see that in that case, Lord Braid refers to a number of cases, and it specifically refers to the case of on the application of Dolan and the Secretary of State for Health and Social Care by the Court of Appeal at paragraph 86. I mean, the Lord Braid cites the Court of Appeal decision and without without any reservation. Do you you've obviously looked at the Court of Appeal decision and the decision at first instance, which Mr. Duncan relied upon. I mean, do you accept that those cases, that case, both at first instance and the Court of Appeal, sets out the appropriate approach for the court?
Well, I'm not so confident about that one, because remember in the Dolan case, and
but you see
within
that Lord Braid in the case which you're relying upon, it relies upon the Court of Appeal decision, and he specifically says that these cases are important because they are dealing with the same subject matter. He says this case is of particular interest since it involved a challenge to English regulations made in response to the pandemic. I mean, he relies upon it, and he doesn't say that he in any way disagrees with the approach taken by the English Court of Appeal in relation to measures introduced by the executive.
Yeah, but my lord, at the beginning of that paragraph 106, we see respondents accept that they have the burden of proof.
Yes.
Showing that the desired level of protection could not have been achieved by less restrictive means. And so there is a burden stated by the court regarding what duties have to be discharged by the respondents in a case like this. And I appreciate what is central to the issue your lordship has raised. That is the role of the court when it's an executive exercising a power. But point number one, bear in mind section 11 of the Constitution. An executive decision cannot be totally dictatorial.
Yes.
It has to take into consideration, before it comes to that decision, what the rights of the citizens are.
Yes. Yes.
And so, in our submission, your lordship is not limited simply to making a prediction as to what might be the consequence if this regulation is introduced. Surely it's a balancing exercise, which should also look at the rights of the citizen.
Yes. I mean, there are other cases which I think Mr. Duncan cites in relation to, specifically in relation to the constitutional provision, which have an exception based upon reasonable requirement as to how the court should approach that.
And so, although that central issue has been identified by your lordship, there is still central to that consideration a decision by your lordship as to reasonableness in the circumstances. And that, in our submission, places a requirement upon the respondents to provide fundamental evidence to explain why in their submission that reasonableness test has been resolved.
And I mean, we've touched upon it before. I mean, they have filed some evidence. You think that what would you expect, which you say would satisfy that? What sort of evidence?
Well, for example, a prediction which has a data basis setting out one of two things. And, what is going to be achieved, what could not be achieved if this regulation is not passed. There are questions which have to be looked at and examined in detail. And in many ways, that's why I began our submissions where I did. Because in many ways, it's that evidential centrality which will assist your lordship in deciding. Yes, I may be just the judge and they the executive. But what's my position based on what has been put forward by the parties in this particular case?
Yes.
So I appreciate the point your lordship has made by referring me to this authority and the centrality of that balancing exercise between the role of the judge and the executive. I appreciate that. But we submit quite bluntly that there are fundamental issues which you have put forward, and in respect of which the respondents are not in a position and have not properly answered.
Yes.
But I agree with you, the point made by your lordship. I think that is the central issue you face.
Yes.
What's my position in relation to the executive? It's a fundamental question. And as we know, the authorities, have set out principles which should apply in those cases. And we've reflected that in the legal part of the submissions we have put forward. So that is the basis at one level for the answer to your lordship's query regarding this matter.
Yes.
But is there something further on this matter upon which your lordship would like my assistance?
No, I mean, it's entirely a matter for you. I mean, it's I'm here to listen to submissions. I mean, is there anything further you want to say?
At this point, I'd rather have an opportunity of speaking with my colleagues.
Yes.
To see if they have criticism of what I've said so far, or whether there's something further they'd like me to say.
Well, so in that case, this is what we will do. We will take the 10-minute break at this stage, and you can have. Would you like a slightly longer time? Would you like a 15-minute break?
15 minutes, please, my lord.
Yes, we'll take a 15-minute break now, and you don't have to disconnect. Just simply turn off your video and sound, and then unless you want to go make further submissions, it would be for Mr. Duncan to start his submissions.
Okay.
But certainly, please feel free to make further submissions if you so choose. But
I will move.
For the time being, we'll adjourn for 15 minutes and resume at, let's say, 11:05.
I'm grateful, my lord.
Yes, thank you.
Hi, Courtney. I'm hoping Aaron can come on.
Mark, hi.
Yeah, hi. I'm hoping Aaron. Hopefully, he was going to set up a separate one, but if you heard that, he can just join.
Wait, guys, we're on the live link with everybody else still. I'm going to send you a separate one.
Okay.
No,
I think. Have a look. I think they're all.
Aaron, you've got to hurry up. We've only got 15 minutes.
All right, you guys, mute your mics.
I think everyone is off, Aaron. Everyone is off. So we could carry on here.
Hi, Mark. I've muted.
No, we're not all off. I'm just letting you know that.
Yeah, could you start?
Okay, that's fine. We'll go on a separate link. It's fine, guys. Thank you. We'll go on a separate link. Okay.
Thank you.
Chief, it looks like they're signed out, so they're gonna have to sign back in.
Okay.
So just waiting for them to pop back in.
Can you come on? I'm on. Delroy, I see you. I'm on.
Because apparently it's on YouTube and people's going
Yes, I'm on, and the chief is
Okay.
on. Chief is on, waiting.
Chief is on?
I said the chief is on, patiently waiting.
Oh, okay. Oh, apologies, Chief Justice.
No, that's all right. Where is Mr. Griffiths?
I'm not really sure at this point, my lord, but the intention after brief discussion was that if I may just parachute in and pick up on a few things and on where the submission is might be of assistance.
Yes, of course. I mean, it's if so, you are following Mr. Griffiths.
I am, my lord.
Yes. Well, I'm happy to listen to you, or do you want to wait for Mr. Griffiths?
Perhaps we could just see if he's coming back on, but
Yes.
I'm certainly in a position to proceed from where we left off and at least take us to the break point and then perhaps consider it further.
Yes.
He's coming back on now, my lord.
Okay.
Okay, I'm getting indication I can go ahead, my lord. He'll come on and be muted.
Yes.
Well, look, could I please just start on this premise in parachuting in that the key considerations, and I say this, for the court on the test at this stage is one, what is reasonably required, and of course that will require some analysis of the evidence, which I intend to highlight to your lordship. But the second, and running from particularly the Scottish case and the case law on it, is the balance of interest. And that is a very significant part of this whole issue. Your lordship in the injunction hearing raised the question at the end, which, if I may say, is in my mind the most significant question in just posing the question as to why the distinction between the vaccinated and the unvaccinated. And that really is what this matter is all about, in my respectful submission, in honing it down as to, is there a valid distinction to be had between the two classes as to what is reasonably required in the circumstances that warrants the imposition of a forced mandatory quarantine on unvaccinated people, and should they be distinguished? Because most of those in other places, one isn't saying there shouldn't be a quarantine. One isn't saying that in certain instances there shouldn't perhaps be a mandatory quarantine in a hotel or wherever else. It's the distinction that is the crux of this case. And my Lord, if I could please make the following analogy for your Lordship's consideration, and then pose the rhetorical question on how does this make sense and how is it reasonable? And the analogy is this, my Lord. A mother traveling with 2 infant children who is vaccinated presents at the airport on return and tests positive for COVID. My Lord, that mother with her children goes home to her house to quarantine. The mother in line behind her with her 2 children, who is unvaccinated and tests negative, goes into mandatory quarantine at her expense. My Lord, in my respectful submission, that is the appropriate analogy and probably has occurred and certainly could occur and is a consideration as in those circumstances, how can it be justified on any evidence that that distinction is reasonably required in the interests of health and in the interest of preventing the spread of the pandemic? Because there is nothing at all where in that type of reasonable example, one could say that the mother going into the forced quarantine has to go there because she's at a greater risk of spreading the disease. She doesn't even have it, but we would classify as being reasonably required that we lock her away in a room for 14 days with her children.
But you say she was vaccinated, she wouldn't be.
Yeah, if she was vaccinated, she wouldn't be. Yes, yeah. If she was vaccinated, she wouldn't be, but she would still be going home, of course. But it's this distinction as to where is any evidence in support of that position that it would be reasonably required for her to be locked away. Well, I use that term without any hyperbole, but forced to not quarantine at home when the mother who has tested positive, who is vaccinated, which of course can occur, gets to go home with her children. How, in assessing the balance of interest between the 2 groups, and let's call them that, vaccinated and unvaccinated, could one possibly arrive at the situation and argue that that was reasonably required?
Well, I think what they say, as I understand their case, Mr. Pettingill, I mean, obviously, one has to, when you're making decisions in relation to a community, you have to look at the large statistical data. I mean, they say that there is a valid distinction between vaccinated and non-vaccinated. And the reason why they say that is that if you're vaccinated, you are less likely to be infected. And they say there is a evidential base for that. There is expert evidence that that is so. And second, which is as much important, even if you do get infected, if you're vaccinated, your viral load is so low that it is significantly less likely that you would infect other people. And therefore, you are in a different category. That's what they say, and that's what they say the evidence suggests.
Yeah, and one can't really, well, perhaps with regard to the new variants, one could go down a different road on that, but one can't disagree with that. But I used, my Lord, with no disrespect, in a gambling sense, with the game of craps, it's a crapshoot make a comment with regard to whether the person who has less of a chance of getting it, you don't know when you send them home. There's still that potential.
Can the executive not make policy decision based upon significant less likely outcomes and take a different view? I mean, that's what they've done. They've taken the view that even if you're even if you're infected, you could, and that's what they say, have that person quarantine at home because the chances of infection are less than the person who's not vaccinated, because that is where the viral load is high and much more likely to pass on transmission.
Yeah, my lord, but coming back to my analogy with respect, how does would the court view that in the circumstances which I've expressed, which are bound to happen and may have already happened, in the sense that we know that the vaccinated person has it, but you're going home, and there's no alternative to that, and the person that doesn't, there might be a higher chance that they're going to contract it on one of those subsequent days. Going to hotel room, but it makes no sense that when you've got a person who actually does have it, that you put them in that different category of it's okay if you leave. I mean, you're a bingo at the gate.
I mean, I can well see that. I mean, one can think of examples which may show that it's not a perfect policy. I mean, one is not in search of a perfect policy which is without any criticism. One is looking for a policy which achieves broadly the desired objective without having too many undue negative impacts. But do you accept the proposition that the scientific evidence now is such, as set out in the various affidavits, particularly the affidavit of the chief medical officer and others, that because there is now appears to be reasonable consensus in the medical community and scientific community that if you are fully vaccinated, that the chances of getting infection are less, the breakthrough infection is less. But more importantly, for present purposes, that even if you are infected, because the viral load is such that the prospect of the fully vaccinated person infecting others is substantially less. Now, if that is the case, do you not accept that a decision maker, a policy maker, the executive, could validly fashion medical policies based upon that distinction?
Yeah, my lord. Yeah, absolutely, absolutely, you could. But let me start on this basis before I concede, before I appear to concede that completely. One, this is a moving goalpost all the time. It seems that every time a different variant arises, or so on, the impact on the level of the risk to the vaccinated person seems to shift. It certainly has with regard to the Delta version of things, that the vaccine is not as effective with regard to vaccinated people, but neither is the disease is perhaps lethal with regard to people generally. So there does seem to be a shifting goalpost, or there is a shifting goalpost on the science of this. But one has to boil down with respect from where, in joining with your lordship on what you have said there, one has to boil down to the balance of interest and what is reasonable in those circumstances. So really the crux of the case comes down to, my lord, let's say we are ad idem on the position that your lordship has just put forward. If your lordship is in agreement with me on the example I've given, which I think is a valid one, and there probably are many others, then that has to be a consideration. What has to be considered, the simple question for the court, and it really does boil down to this, is in all of those circumstances, in consideration of the policymaker, is it reasonable to say, not whether there should be a quarantine or not, and I'll come to that, not whether there should be a quarantine or whether there should be measures addressing that, but to whether it's reasonable to have the only alternative, and that's all we have right now, is that a person who is unvaccinated has to go into a mandatory quarantine paid for them at a hotel. And the consideration for the court, in my respectful submission, on the basis of the law, has to look at it and say, is that reasonably required in those circumstances? And is there a balance of interest to be had here? Which means, in boiling it down, my lord, are there other reasonable measures on the basis of addressing and ameliorating the risk of which we speak, more reasonable to be imposed?
Well, in
And
relation
would
to
achieve, and this is the key, and would achieve the same effect.
Well, in
would
relation
achieve
to that, what approach should I take? I mean, I look at the affidavit sworn by the Premier.
Right.
He says that he expressly states that we considered other options as to
Yeah.
whether other quarantine options were available, and we discussed it at the cabinet level. But eventually, we decided that that wasn't realistic, because he among other things, he says that the only way it could be enforced would be by employing the regiment, and that wasn't effective because it doesn't have the resources. But when the court has affidavit evidence from the Premier saying that the options were considered, but it was decided against it, and the quarantine at home was decided against because, among other things, past experience shows that the compliance with the home quarantine is substantially less than would be the case in the mandatory hotel quarantine. How should the court approach this in light of?
Yeah, my lord, I think the court, with respect, and oblige your lordship for the question, has to approach it on assessing the Premier's position on that, and then moving to the provisions of the Constitution with regard to what is reasonably required, and moving to the case law with regard to what is reasonably required in the balance of interest. It is entirely open to the court to say, is that position, in all of the circumstances and considerations, a reasonable one to adopt when there are, which I will make submissions on, my lord, and which the experts that we have filed evidence on, there are other alternatives which will achieve the same ends on I would say, a very, very significant comparative analysis, would achieve the same ends and the same means, as opposed to the ones that you have suggested. That the balance of interest on with regard to health, and to your lordship's point, not just the individual rights, but the protection of the public, can be addressed by these other provisions being imposed. And all of the ones there I take issue with regard to that it would be more than reasonable, and that the government could accomplish the same position with regard to the approach, as opposed to the mandatory quarantining in a hotel room, which certainly the experts seem to be inclined to is just an unhealthy measure, particularly on people that are healthy. It's just unhealthy. And then we have the whole subcategory.
Ms. Perring, the reality is that there is disagreement. I mean,
well, there is.
Certainly, the evidence filed on behalf of your clients suggests that there are other measures which could achieve the same result. The evidence filed on behalf of the government says that will not work.
Yeah.
I mean, what is the court to do in those circumstances?
My lord, that's where we have that wonderful scale of justice, that the court has to look at that, and on the basis of the evidence, on the basis that our clients, have a constitutional right.
You have frozen.
With regard to, apologies, my lord, I cut for a second there. Have the right to do that, and then in those circumstances, it is for the court to assess and say, is what the government is proposing reasonably required, and is there a balance of interest to be had here? It is not, with respect, enough for the government just to say, this is what we've considered and this is the only thing we can do, if there are other considerations to be had. And that's the balancing act for the court. That's why we're here. That is the balancing act for the court to be had. And if your lordship is able to, as I'm going to be encouraging your lordship to do, to look at those provisions and say, the court takes the view that the position taken by the Premier and by the government is not reasonable in all of the circumstances. And by the way, that would be posed on the basis that, you know, addressing the pandemic and addressing various restrictions and having a quarantine, that all of these things are reasonable. However, it just goes too far in the balance of interest. And that's a matter for the court. And that's why we're here. And that's what I certainly am urging on your lordship. You know, there's a whole class of considerations to be had that, you know, that have not been given, and that the government does not, in my respectful view, consider valid options with regard to that are more reasonable, that achieve in a large percentage the same ends. So to say we've had one example, no prosecutions or anything like that, or even reported, we've had one example of a person who has breached quarantine. That, with respect, is not enough, I would suggest, in the interest of this case, to say, therefore, it's reasonable that all unvaccinated people must have this forced quarantine. I mean, it's going to happen.
The evidence, if it's to be accepted, is that one incident led to 21 deaths.
That one incident led to 21 deaths?
Yeah.
Well, that, I think, my lord, with respect, that seemed to be what the assertion was, but I didn't take it that there was that one incident that led to the unquarantined person breaching that led to. I'm sorry.
May have led to.
Yeah, I mean, my lord, with the greatest respect.
No,
let
me just go back on what we discussed in relation to the conflicting evidence, right? You say that I should take a view as to which one is more acceptable. I suppose this is expert evidence. But how is this consistent with say cases such as the Dolan case, which went to the Court of Appeal? And the Dolan case is as I say, cited in the Scottish minister's case. And this is, you don't have it in front of you, I'll just read it. This is in the Court of Appeal, paragraph 90. They say, we find it impossible to accept that the court could possibly intervene in this context by way of judicial review on the ground of irrationality. There were powerfully expressed conflicting views about many of the measures taken by the government and how the various balances should be struck. This was quintessentially a matter of potential political judgment for the government, which is accountable to Parliament and is not suited to determination by the courts. How do I square that?
Well, first of all, working backwards, they're not accountable to Parliament on this, and they haven't been accountable to Parliament. They haven't even had a vote on it. They haven't even had a discussion on it with regard to negative resolution. It's the regs, so it runs through. And that's a very valid question your lordship asked there, that is not on all fours with that case, which are of grave concern, because it is Parliament where at least the public has to have that say, and one can have some debate on it, even with regard to a negative resolution position. That simply has not happened. And were it to be the case, which I would like it to be, I'd be able to say to your lordship, well, yes, there is that, which would be accountable to Parliament.
I think that if it was approved by Parliament, it would then paragraph 90, which I've just read, would apply.
If it were to be approved by Parliament,
yes.
My lord, it would depend on all of the circumstances. But the fact of the matter is that it hasn't happened. It hasn't happened in Bermuda, and we have a Parliament, and it's a very key question, and it does not leave it on all fours with that particular case.
I'm asking you as a matter of principle, because I mean, I need to have an understanding what your submission is. I mean, the paragraph 90, which I've just read to you, seem to be suggesting is that, you know, where there are conflicting views in relation to the medical community, scientific community, as to the best way forward in the middle of a pandemic, it is for the government to decide which action to take and how the various balances should be struck, and that the last sentence basically says that it's not for the courts to get involved in the middle of it and say this is what you should have done. Would you accept that?
I'm sorry, my lord. I missed your last point. It's not for the courts to get in the middle of it. Yeah, my lord, I do, but it's the key point is what your lordship said at the end, and they're answerable to Parliament. That's the problem here.
But I mean,
that they're not.
let us just assume that this measure had been taken to Parliament and
Yes,
it had been approved. Would you accept that in those circumstances, it's not really for the courts to say, well, you know, we fully accept that when the cabinet was sitting there, they had these various conflicting medical evidence, and they chose one. But I'm sitting here as a reviewing court, and in my view, that was a wrong decision. You should have gone to taken a different path. I mean, you accept that that's not really open to the court, is it?
no, with respect, I would say in the circumstances, it would still be open to the court depending on what the situation was. And certainly if the decision, like let's say, for example, was irrational, it would be open to the court to look at it, or if it met the test.
Yeah.
But the problem is this, my lord, that, you know, I embrace that point, because we have to look at what has actually occurred here. And what has actually occurred is that they're not answerable to Parliament on this issue. And therefore, in my respectful view, where else does it go? It must fall back to the court.
Yes.
I mean, it's negative resolution because it's regulations. And two, even with those, because the manner in which it was dealt with, it hasn't had any form of debate in Parliament. And as your lordship rightly points out, there is a significant class of people, both political and otherwise. We've heard from the opposition on this regard, like, you know, publicly, but there's a significant class of people that are opposed to this approach, i.e. mandatory quarantine. Unfortunately, the only place they're able to be heard is in the press and not in the House of Parliament. So just in the circumstances of this case, it has to fall back to you.
Paragraph 97 of the same case, this is, I mean, and it's dealing with the same subject matter, COVID restrictions in England. Paragraph 97, the last two sentences state, the fact that others may disagree with some of those expert views is neither here nor there. The government was entitled to proceed on the basis of the advice which it was receiving and balance the public health advice with other matters. I mean, do you as a general principle accept that?
Sorry, my lord, I missed the last question.
Well, I was reading paragraph 97 in the Court of Appeal.
Yes, I've got that, yeah.
And the last two sentences state, the fact that others may disagree with some of the expert views is neither here nor there. The government was entitled to proceed on the basis of the advice which it was receiving and balance the public health advice with other matters. Do you as a general principle accept that?
No, I don't, my lord. And let me say why. I may accept that with regard to what the UK authorities are, but that has to be read with respect in relation to our constitution, a fixed and written constitution, which has to look and say, are those things reasonably required? Entirely different approach to be taken there. That I wouldn't say that that's applicable when one is considering Bermuda constitutional law, that it has to be looked at, and those competing factors, if you will, or that competing evidence has to be considered. And that's a distinction with that case, that it's not applicable, in my respectful view, to the caveat of 11.2 in the Bermuda Constitution. Is it reasonably required? And I, with respect, would say you can't then read in a provision from a Scottish UK case that's saying the government can just take the evidence that it has, well, I mean, whatever that is, and rely on that.
Relying on the Scottish case.
I'm sorry?
You are relying on the Scottish case. It's your case.
Well, in part, yes, in part, of course. But one has to read any of these cases, all 23 of them and everything else, in relation to the Bermuda Constitution. And we don't have the case law dealing with a pandemic situation. Probably that's why the government warned about not taking account of, you know, things that are transpiring in the jurisdictions. My lord, there is a framework to be had from the precedents, from UK precedents and so on. But then one has to read that as against plucking the plums, if you will, what is the most applicable thing to apply to our constitution. And what the court, in my respectful submission, has to do here is consider the provisions of Section 11 as relates to what is reasonably required. And that can't be obviated by saying the government can just take the advice that it wants from paragraph 97. That's a one-liner in relation to that application, but not something that I would say with respect that can apply sensibly to the situation that we have in Bermuda. It's distinguishable because of what's required by the constitutional provision.
In considering reasonable requirement under the constitutional provisions,
Yeah.
What approach should the court take in circumstances where the decision made by the government was made in light of conflicting evidence, conflicting expert advice? And is the court does the court simply ignore the fact that it was a government decision and makes the decision afresh and substitute it? Or does the court say, well, in light of that conflicting evidence, the decision made by the government was a reasonable one?
Yeah, my lord, I think that there has to be the consideration of the two sets of the evidence. I mean, the government, the court is entitled to take the position that the government mostly got this right, but on the balance of interest, that it has gone too far, if you will, with regard to the imposition of a paid quarantine, and that is not, in the court's view, reasonably required. That everything else the government has done is, wonderful and great, but that this has been a step too far as the reasonableness and the reasonably requirements in order to curb the concerns. Entirely open to a consideration of the court, particularly in these circumstances, particularly when, as your lordship has indicated, there are two very significant classes of people that have issues with regard to constitutional issues, with regard to what has been implemented, particularly when there is conflicting evidence. And I would say it is about finding a balance on that evidence. And coming back to the point, my lord, that this is a very particular issue with regard to the requirement of a mandatory quarantine, not a quarantine, not provisions, not taking precautions, not doing things that are necessary, but the evidence that relates to, does the evidence support, and I say it does not, the evidence support that a mandatory paid for quarantine is required. That's the crux of the application, and that the evidence does not support that. It supports quarantine, it supports measures, it supports, positions on isolation, does not support a paid for quarantine. And if on the face of that evidence it does, it's for the court to then say, are there other things in the balance of interest, which has to be considered, that achieve the same ends in large part? And that is what, with respect, I think has to be the consideration, that balance of interest. Are there other means and measures which are set out in the evidence, which I'll come to, which achieve the same ends? In other words, we are at item with what the government is saying. It's just this one significant twist, if you will, about the approach of the mandatory position of unvaccinated people, which I say in a gambling term is a crapshoot. Even if it's a less percentage that somebody who is vaccinated will get it and transmit it, you still don't know whether that person that you send home may be the person that does it, as opposed to the person that goes into a mandatory quarantine. It's just a question of percentages that may shift. And then there are all of the other health considerations to be had that are fundamentally detrimental on the evidence to people being placed in a forced mandatory quarantine. And those have to be questions for the court. My lord, if I may, having had this important exchange, to which I'm obliged for, I think if I could endeavor to, at this stage, looking at the time, come back to the submission I'm going to suggest at paragraph 17 and endeavor to go through that leading into the evidence. I think that may assist, my lord.
Yes.
Thank you, my lord.
Paragraph 17, yes.
Paragraph 17 of our submissions, my lord. So this is important, my lord, and this comes down to your lordship's questions with regard to the approach of the government and their considerations and the Premier's affidavit and the considerations of why they have done what they have done in relation to having a forced mandatory quarantine. I think your lordship highlighting that it is important to consider the policy and approach of the government and how that impacts on what is reasonable. I'm not going to do that by way of looking at what they have said and what they have done. I mean, we are some way down the road. Your Lordship made the point earlier about, it may be the case. It may be the case. It was pretty speculative that the one person that breached quarantine, has gone on to cause that type of devastating impact. But it is somewhat ironic to me, and not lost on any of us at the time, that no action was taken of this magnitude at that time, when the crisis seemed to be at a height, that it wasn't reasonably required then. And for some reason, it's reasonably required. It's reasonably required now. That, we say, does not support the position on the action the government has taken. My Lord, so paragraph 17 on page 4, on June the 29th, the second respondent, who is the Minister of Health, is obviously named in these proceedings, is very significant to it, gave the following caution to the public. Persons who are vaccinated should also remain vigilant, because the vaccine does not guarantee that persons won't catch COVID-19. The vaccine is highly effective in protecting severe illness and death, but the level of effectiveness does not vary across the COVID-19 variants, to a point that I was making earlier, and where I say this becomes something of a gamble, my Lord, between who gets to go and who has to stay. It's very, very clearly the position of the government that it's not as effective across all of the variants. So you don't know what variant you're dealing with, or what position somebody is in when they initially present. Hence my analogy between the vaccinated mother and the unvaccinated mother. I strongly suggest that you do not use international news sources as a guide for the COVID-19 situation here in Bermuda. Our policies are specifically designed for the Bermuda context, and although they may be different from those of other countries, they are deemed most suitable for the safety of the community. Pause, if I may, my Lord. That has to be read, in my respectful submission, in the context of the Constitution. It's not simply a question of that they are deemed most suitable for the safety of the community, but it's a question of, are they reasonably required in the interest of the safety of the community, which is exactly the position that we have to look at, and that we say that in these circumstances of a forced mandatory quarantine, while we have to look at what is suitable for the safety of the community, we have to balance that on a balance of interest with what is reasonably required in the interest of the whole community. My Lord, at 18, the evidence adduced by the respondents in the present proceedings, nevertheless is predominantly based on international sources. That's, if we look at their evidence, my Lord, despite that statement, and even when it comes to the case law that we've had to use, that's why I'm saying these distinctions have to be drawn, even on how we apply the case law, most of which may be useful, but then has to be read in the context of the Constitution very carefully. So most of the evidence that has been presented by the government's experts, in fact, does nothing but rely predominantly on the international sources. My Lords, we say that that evidence lacks fact-specific and contextually relevant data directly relating to Bermuda's epidemiological situation, and is devoid of any contemporaneous evidence which the respondents ostensibly relied upon on the basis for their decision to announce on the mandatory 14-day hotel quarantine. The evidence, my Lord, must substantially support, and I say it does not, must substantially support the position that a mandatory 14-day quarantine is reasonably required for unvaccinated people. And the evidence on the face of it, and that is a summary of it, simply in our respectful view, does not do that. Before we bring in the countering evidence, the evidence on the face of it does not support that position. There's one thing for the government to say, we rely...
You're never going to get evidence which is going to support that particular proposition, but you do have evidence that there is a distinction between the vaccinated people and unvaccinated people. The risk profile is completely different, and the risk profile for transmission is completely different. That is the scientific evidence. And on the other hand, you've got evidence, at least on the face of it, evidence which suggests that there is less likely chances of transmission if people are quarantined in government mandated hotel quarantine than at home. There is evidence of that. The question is as to whether from those two sets of expert evidence you can reasonably conclude that in those circumstances a hotel quarantine is reasonable. But
Yes.
there is I mean, you can't just say there's no evidence. There is evidence. Obviously, the final issue as to whether government mandated quarantine in a hotel is reasonably required is obviously a policy decision, but it's based upon some evidence.
Oh, my lord, one swallow does not a summer make, and of course, there is some evidence, but it's characterized by use of the terms may. It's characterized, and I'll come to it with regard to a comparative analysis in one instant from the UK expert. I'm sure your lordship read this with the report that she filed that makes a comparative analysis to Wuhan and why it was necessary there. And the reason which one could see is because they were not able to educate the people in the area because perhaps it's rural for other reasons, not able to, have the media sources or whatever, or the electronic media sources, that this was the reason they had to do it there, because there wasn't the ability to reach the masses, if you will, with regard to what was required. That's their evidence. So there may be some evidence, but then when you look at the evidence and you see the exhibits applied to it, you're doing exactly what the government says one should be cautioned about. You're looking at the Wuhan model in China. And one has to resolve from that entirely and say, well, what should reasonably the Bermuda model be? Because we can achieve all of those things here. We know we can do that. It's mass media. Everybody's on their phones. Everybody, it's a wealthy country. Everybody has the ability to ensure that the message gets out. And the government, I may say, has done a very, very effective job with that, a very effective job of getting the message out. And I will come to, my lord, in due course, when I ask your lordship to consider the alternatives. Legislation has been passed, regulations have been passed repeatedly with regard to how things are dealt with. And, upping the fines and upping the ability to do checks and so on. I would argue that the majority of people in this country will be compliant, as they have been. That's why we don't have any prosecutions in relation to the quarantine position. But there may be some evidence.
But just pausing there, I mean,
yeah.
The evidence from the health minister is that there hasn't been compliance, and she gives those examples. I mean, that's one of the reasons why she said the policy was changed.
Well, my lord, I'll come to that too, because it's like, as I say, I don't. There's some
that's the basis for introducing the new policy, because they did have previous policy which they said didn't work.
Well, my lord, this is where people need to be. The way you deal with that before you get to arbitrary detention, with respect, is you change your rules and your regs if you want. And the government did this with regard to other things. You up your fines. You up your imprisonment position. You get the message out to say, this has to be taken seriously. You have to stay at home. And if you don't, if you're caught being out, you are subject to a $20,000 fine. You are subject to $20,000, and get people before the court. Because I have to say, I find it significant that if that is the case in a matter this serious, as to why the government hasn't put people before the courts and made examples of them with regard to that position. It's not just enough to say there have been or there may have been these incidences of breaches that do that, and that is a concern. Those things should be addressed. That's number one, and they haven't been. And had they been, one could see why we're in this position saying, look, we've exhausted all reasonable positions with regard to addressing this issue. People aren't getting the message, and the only way we can deal with that is to lock you up. You unvaccinated people who are really the naughty ones. For some reason it's become, the unvaccinated people are going to be the ones that are the naughty ones, but the vaccinated people will all behave. With the greatest respects, my lord, that is just a nonsense. People are people, and they may choose to get vaccinated, and they may choose not to get vaccinated. Hence my embracing of your lordship's point to the question you posed to my learned friend at the injunction hearing. How do you distinguish between these two groups of people? I took that to mean, my lord, how do you distinguish between who is going to behave and who is not going to behave? And the answer to that is you can't. You can't. You can have like people that are willing to flagrantly disregard the rules and who are vaccinated and still at risk. And then people that for whatever reasons, for personal reasons, for other reasons, that they're scared or whatever, that there is not enough information, that they see this as an experimental vaccine, not FDA approved, which it is, and therefore they're not convinced that it's in their health interest to do it. Younger people that have looked at it and said, I'm only 18 years old. I don't really feel on the basis of the evidence that I should be getting it. All of those reasons. How do we categorize them as being the naughty ones that will not comply with reasonable measures to say you must quarantine at home? You must quarantine at home. Now, I mean, I don't think she'd mind me saying this, but I mean, I have a daughter currently in quarantine who was unable to get the vaccine in the UK and has had COVID. So would have the antibodies. I mean, and she's not one of the naughty ones, I'm confident. I'm sure there's a whole class of people that fall into the category that she is with regard to how she would self-isolate and so on. So we can't, that's where this becomes a balance of interest, because it's not just about, and should not be about, and must not be about the vaccinated or the unvaccinated, because what it smacks of, if I may, is by imposing this type of condition where you have to pay for it, is really, we've seen the carrots of get a vaccine and you'll win a prize. Get a vaccine. I said before, my lord, in relation to Virginia, we'll give you a gun. If you fall on the Father's Day present list, if you get the vaccine, all of these things to encourage people to do it. We've had those in Bermuda, and here comes the stick. If you don't, you're going to pay to be locked away. Whether you're a good person or a bad person, or whether you are a compliant person, there's no rationale or test for that. And because there may have been an example, of somebody who breached a quarantine, as I say, one swallow doesn't a summer make. That is not going to impact on all of those other individuals that will be compliant. And what I would suggest, my lord, and I'm going to come to it, is that in addressing that, the government can consider other measures that are far more reasonable, that allow people to remain healthily in their own homes, instead of being in mandatory quarantine. Sorry, my lord, I digressed in relation to your question, but it's important. I'm at 18.2 now of the submission.
These are your submissions.
These are submissions. I'm sorry, my lord. Yeah. And this is addressing the points on the government on our respectful view with regard to the government evidence. Yes. That too, my lord, it's littered with references to material which with respect is ultimately irrelevant and immaterial to the considerations invoked by the applicant's constitutional challenge. 3, does not in any way discharge the requisite burden of proof as detailed below. And 4, demonstrates the mandatory 14-day quarantine is irrational and discriminatory. And my lord, if I may, because I didn't mean to resile from the position of talking about irrationality, but I think I would invite your lordship to consider that the example that I started with between the vaccinated mother and the unvaccinated mother, and the example of that at the air, that is irrational. And I would submit that example, that approach, it's not just unreasonable, it's irrational. That those two sets, if you will, of a vaccinated mother and unvaccinated mother, one testing positive would get to go home. There is no rationality to that. And I agree with your lordship. There may be many other examples, but that one, I would say, is a real possibility, but is an example of where not only is it not reasonable, but it becomes irrational that could be the case. My lord, at although we seem to have doubled up on the numbers here. For some reason, I've got a 17 again. Forgive me. I think that should be 19. But for these purposes, I'll read it as 17 at the bottom of page 5.
Yes, and you repeat
under the no direct correlation. Yeah.
Yes.
At that 17, my lord.
Yes.
And then we pick up. We'll pick up at 19. The applicants recognize that some restrictions may be necessary and have indicated their willingness to abide by the lesser restrictions which are already provided for in the respondent's regulations, i.e. home quarantine, the fitting of ankle monitoring bracelets, devices, and so on. Now, what we say in that regard, my lord, right now, and let's think about this as far as being reasonable, the government has said it doesn't have the resources. Pause. Well, you're demanding that people pay to stay at a hotel, have them stay at home, and pay for what other requirements are needed there. That's reasonable. That's rational. So instead of having to stay in a hotel, wouldn't it be easier to have the monitors on? We know there's monitors. They're available. We can get them. Have people pay for those. And with respect, I would say that that is a consideration for the court with regard to what is reasonably required. If your lordship were to be with me after argument on the basis that the mandatory paid for quarantine goes too far in the circumstances, the next question for the court is what is reasonable and could have been reasonably considered. And that is a perfect example of that. And also in considering that constitutionally, the court is considering what is in the best interest of public health as the Constitution demands. And what we are saying in that regard is that the evidence, either by way of conflict or by way of support for the evidence for the applicants, indicates that the forced mandatory paid quarantine is not reasonable. My lord, at the second 18, the respondents have failed to provide any evidence which addresses the applicants directly insofar as providing any rational reasons based on localized fact and context specified with COVID-19 data as to why these applicants cannot be trusted to quarantine in their home or be subject to one or the other less intrusive measures, such as the fitting of ankle monitors or other monitoring devices. And the urgent point on with regard to it, we are dealing with these applicants. Surely it has to be a question of looking at applicants, these applicants and other applicants of their ilk, and saying that the evidence is on the balance, that people will not be compliant, and that this is the only way that we can deal with them.
Well,
and we would say that just cannot be correct.
That's what the government says.
Yes, I think, well, my lord, with respect, they say that on the basis of speculation, on the basis of that this may have been the case before. But just because the government says it doesn't make it thus. One has to then.
No, I don't think we can just brush it off like that, Mr. Pettingate. There is the evidence of the past practice, and then there is the expert evidence which has been filed. I mean, and you know, you have to have to at least acknowledge that there is evidence from an expert who says that all things being considered, it's less likely to be effective to have home quarantine than government mandated. I mean, that's the evidence that it says. You may disagree with it, but there is the evidence.
Well, what was? I'm sorry. Forgive me. What your evidence? Your lordship summarized that evidence as saying that there is evidence that the.
Yes. Well, we can look at it if we.
Yeah.
I thought you read it, but maybe let's.
I have read it. I've read it all.
Yeah, but let's have a look at the affidavit of Joanna Peden.
Yeah. This is the UK. This is the UK expert.
Yes, but if one works on the basis that the human beings generally behave the same way, in conclusion, having reviewed the evidence on quarantine hotels and self-isolation at home, the evidence shows that the quarantine non-vaccinated people in quarantine hotel ensure stricter adherence. Evidence around behavior shows that compliance with home isolation is low. It is especially important with the rapidly developing risk of new variants emerging that a precautionary approach is taken to ensure that the vaccination program is not undermined. I mean, that's the expert evidence. You may say that that's wrong, but that's the evidence.
No, it's not that I say that is unequivocally wrong, my lord. One, I say that that's a UK expert analyzing a UK position, not a Bermuda position, and that one had.
Let me just. I mean, you say that. Why do you say that the Bermuda position in terms of home quarantine and hotel quarantine is different? than the UK?
Oh, my lord, because the UK is a vast place with millions of people. We are a small place where we have, I would say, the means and the ability, and this has been shown, to regulate the position more easily than it can be regulated in the UK if one has to look at it. They're entirely different, as are what behaviors may be. One has to, in my respectful view, and to the health minister's point, look at it in the context of Bermuda. And first of all, the requirements of the Bermuda Constitution, which isn't in the UK, and also the Bermuda community. We're a small town with extremely significant resources that can be applied to addressing this. Everybody is, I hate to say it, it's Bermuda. Everybody's in there, everybody else's business. You can look and say, people are paranoid about this type of thing. That's my unvaccinated neighbor sneaking out of the house at night. It's widely publicized, it's widely known. To take her point with regard to the Wuhan model, and I would say that UK position is not as applicable to Bermuda. That's why the health minister made that point. Be guarded in how much you pay attention to the international position. I find it somewhat ironic that they went and got the evidence from a UK expert who is applying what transpires in the UK, but that has to be looked at in the context of Bermuda, both constitutionally and factually. It's not enough to apply those behaviors or that type of vast number of people as spread out as in the UK to our country, in my view. It has to be a subjective test to Bermuda, my lord, in the balance. It has to be. Thank you, Lord. My lord, I'm at 20 of this position.
Yes.
Well, look, can I just check again? I apologize. Was it, your lordship, we're going to sit until 1 o'clock?
We're going to sit till 1 o'clock, yeah.
Okay, thank you, my lord. A lot of time. So, my lord, and let's address this with regard to what is reasonable and rational, and why people on their behaviors. It's the unapproved nature of the vaccine, because one speaks of a vaccine, it's something of a misnomer. It may be ameliorating to the health concerns as relate to COVID, but it's not a cure-all, as many other cases are. And I did actually, on your lordship's bringing it out, go and read the Czech case, the Czech Republic case. And of course, that was dealing with a vaccine in the true and proper sense. And I say that is wholly distinguishable from what the current position is, particularly as applies to people's behaviors in deciding that they're not going to be vaccinated. So 20, my lord, the respondent's evidence fails to address the...
Just on that, Mr. Perry,
yeah.
Paragraph 20, but there's a consensus of evidence that those who are vaccinated are less likely to contract the virus, and if they do contract the virus, they are less likely to be severely have severe health issues and likely to be hospitalized. And
yes.
There is a consensus of evidence that even if they are infected, they are less likely to transmit to others the virus because the viral load is less.
Yes.
For present purposes, that's the important point, not
yes.
whether the vaccine's been approved or not.
I accept that word. For present purposes, I accept that. That's the starting point. I guess, my lord, that point, to my point, with respect, that the concerning feature of this, if you will, and even the question your lordship posed before, is this distinguishing in classes between the vaccinated and the unvaccinated. There are perfectly, such as our clients, perfectly normal, law-abiding citizens, I'd say they are entirely in the majority, who, for a number of reasons, and many of them could be scientific, because there are shifting of the sands. I mean, I think initially, the government in its health release on policy advised that, pregnant women or those intending to be pregnant shouldn't get the vaccine. That was the initial release. And then the minister stated that it was okay for pregnant women to get the vaccine, that it was safe, but it was something that continued to be monitored. And then it was, you can go and get your children under 18 vaccinated. Candidly, personal note, I find that an abomination. But, you know, that was one of the things that was being considered. Then the health organization comes out and says, oh, children under 18 shouldn't get vaccinated.
But I mean, why is that surprising to you? I mean, this is clearly a developing scenario.
Yes, absolutely.
We had a pandemic which is now 18 months old or thereabouts.
Yeah.
Vaccinations have been developed. There isn't the experience. There isn't the history, and therefore science develops, opinions change. The position changes on a daily, weekly basis. I mean,
not surprising at all, and that's why I'm sure that your lordship may consider. You know, if I pose the question, why would it be surprising that people were hesitant?
No, it's understandable. I mean,
I'm sorry?
It's perfectly understandable if people are hesitant, but that's not the issue.
Well, it's part of the issue, my lord, when one considers, coming back to the Constitution, what's reasonably required to deal with those people. Yeah. It's entirely relevant. If one can go far and say you understand why they're hesitant, the next question is, how should we reasonably deal with those people that justifiably are hesitant? Because it's not surprising that the science changes all the time. No, I entirely, I'm not an anti-vaxxer by any means, I'm vaccinated, but I can entirely understand why there are people that are hesitant.
But the science has, there is a consensus of science that the risk profile which the non-vaccinated people have is different from the vaccinated people. And in those circumstances, as a starting point, I would have thought that you tell me otherwise, that the government would be entitled to formulate policies which take into account the different risk profiles.
Totally, of course they are. And I wouldn't tell your lordship otherwise that they're not entitled to do that. What I am saying, we're at item on these things, but what I'm saying is they've gone too far when it comes to the imposition of a mandatory paid for quarantine for unvaccinated people. You know, commend the government on the work they've done. What it is, it's a bridge too far, to use that analogy. This is the crux of the point. It's not that they can't do it, it's how far have they gone, number one. Is that reasonably required? We say no. We say because in the balance of interest, there are all of these other factors that you could impose and could be considered that make it reasonable with regard to addressing those people who are, your lordship's term, hesitant with regard to things, who are law-abiding citizens.
So you say that you would accept home quarantine, you would accept sort of periodic visits by the regiment, would you?
Yes, I've had them. My lord, I think the last, and I'm not mean to give evidence to you, I'd ask the court accepted as an officer of the court, but I mean I had to go away, happened to be for medical reasons, but returning for medical reasons, and you know, within an hour, the regiment not only were calling, but calling from my parking lot. Could you pop outside? You know, and I had no problem with that. I actually thought it was quite sensible. And you know, and where are your children? I thought that was sensible. No problem. Here we are, guys. You know, here's the wristbands on. Within an hour of or so of arriving home after a lengthy process at the airport, they were there, and a plethora of people. The same thing. And so that's where I frankly, with regard and with the greatest respect to the Premier's position on that, the regiment are out there and have been doing it. And it's not like, in order, by way of analogy, if you want to stop speeding, you have to put a policeman on every corner to watch every driver. You do it by random checks, and you let people know we're doing random checks and we're going to check on you. And it seems like they were checking on a lot of people, and people then beware, I could be next. You know, that the regiment or the health officials are driving around randomly or otherwise and checking on people. To say that they have to check on everybody, with the greatest respect, would be a nonsense. Or that they would have the means to check on everybody would be a nonsense. But if people are aware that they are going to be checked on, or they could be checked on, it's a reasonable measure. It keeps law-abiding citizens in their place, so even in times such as these.
Your objection is not against quarantine. Your objection is not against being checked by either the police or by the regiment. The fact that they have to stay in a hotel and pay.
My lord, that is the crux of the entire case. There is no objection whatsoever to the fact that the science supports that quarantine is an important measure. That, the science supports that, measures have to necessarily be taken. That the fact of the matter is that the government has done a very significant, outstanding job with regard to addressing this particular pandemic. However, that this measure it goes too far, it's unreasonable, it's unnecessary, and in certain aspects, it's irrational when it comes to the analogy that I gave. That's it. That's all that and the only possible place to have that addressed on the basis of the law is with your lordship. We're just asking for a step back from that, a very reasonable step back from that, a very reasonable application of the funds instead of going to the hotel. Here's another point. Instead of having government spend more money on students who are going to be able to stay at the hotel without charge, instead of having them do that, to have the money applied to the enforcement of the reasonable measures to stay at home, to increase the penalties, my lord, if you don't stay at home, to put a notice up outside your door saying, if you come to this house, this is an age-old approach, you have a sign outside the door, if you come to this house, these people are under quarantine, like putting a ribbon around the house, you will be subject to the penalties of the law. And to pass those laws, which they can do very quickly, pass those laws, and as they have done all along, to let everybody in this country know, unlike in Wuhan, where you couldn't do it, let everybody know this is the law. If you go into this person's home and they're under quarantine, you will be fined $10,000 and subject to 6 months in prison. If you step out of your home and you're under quarantine, you will be subject to this. You will be regularly checked or open to being regularly checked. You will receive phone calls. All of those measures, the applicants are not have any objection to those, and right-thinking people have no objection to that type of approach. And most importantly, that type of approach, the evidence would indicate, and common sense would indicate, is there to be availed by the government. And then one has to question, why would you go as far as you have with regard to requiring this lockup of non-immunized people when there are all these other reasonable approaches that could be taken? My lord, if I could come down to 21 on page 6, discriminatory.
Yes.
Thank you. The risk of variants entering Bermuda is not limited to unvaccinated individuals. The respondents accept that vaccinated individuals can still catch and transmit COVID-19. Your lordship and I are ad item on this. It's less, no question. It prevents it. But my lord, again, I have to use that term. It's still a crapshoot, because you take the temperature, you take all the reasonable measures. The reason that we have follow-up testing is because of the time of the incubation. So let's say, and there's some evidence that supports this, that it's 30% of the people that have contracted COVID are actually vaccinated, because no question that we know people that have contracted COVID-19 have been vaccinated, have had the second vaccination. So a person comes in with the vaccination certificate, it's not a silver bullet.
No,
that's why it's not a true vaccine.
But I mean, national governments make policies based upon risk profiles of the population. I mean, just this morning, if you've been listening to the British news, I mean, there is a proposal that which will be decided upon in a few weeks' time, that anybody who's fully vaccinated can go into the United Kingdom without any quarantine, which would not apply to those who have not. Now, that would be a straightforward distinction based on whether you've been vaccinated or not. That is a national policy they are considering whether to adopt or not, and it apparently will be decided in 2 or 3 weeks' time. But obviously, all of the points which you make will still apply, but the government make policies on broad policy consideration, broad profiles of the population, and that's based on the premise that those who are fully vaccinated are less likely to transmit, and therefore, I mean, in that case, not even a test apparently would be taken. required as to whether you test positive or negative, either before boarding the plane or when you actually enter into the United Kingdom. It simply is based upon, have you been vaccinated, fully vaccinated? If you have, you can come and go freely.
Now, my lord, it sounds to me, and
those who have not will have to take all the tests and be quarantined.
Quarantine at home or quarantine institution?
Well, it doesn't matter, but I mean, that is it's a stark distinction based simply on the status of being vaccinated.
Yeah, my lord, that may be the approach that they're taking, but with the greatest respect, I say it does matter if the other people have to quarantine at home, because that's what this case is all about. If they're saying then, and everybody who isn't has to be, locked away for a period of 14 days, which I'm going to come to that, because I would say that's extreme by any measure. To that point, it strikes me this: when we talk about irrational, if you look at the law as it currently stands, and I digress for a moment, if you go into a quarantine position in Bermuda and on day 14 you test positive, you go home. That makes no sense whatsoever, as far as the reasonableness of a policy that you can stay for 14 days. If you're an unvaccinated person, we forced you into it, and for some reason, maybe you catch it while you're in there from somebody who is serving the food or whatever somehow, and on day 14, you did, the way that the regs are structured, you would have to go home. But it matters not. I digress, my lord, because there are many other measures. Like in the UK right now, they've got, if you're coming from a particular red zone, and there are classifications of the danger that's highlighted from where you're coming from. And in those instances, it may be sensible that all people quarantine for a period of time, because there is a risk associated, particularly with shifting variants. When you talk about the Delta variant, the vaccine is not as effective. That's just a fact on the science, which I'm sure your lordship's aware of. It's not as effective. I mean, I'm reading reports today, I think on the BBC News, it was saying that, if it's 70% effective or 80% effective in relation to vaccinated people, that there's a substantial shift in the other direction with regard to the other variants. And that's where the shifting sands occur on the science. But it all rolls back to, how do we deal with the quarantine aspect? That's all this case is about. Not the policy of the government, which may be well justified and has been all along in particular measures, but how do we deal with this quarantine aspect, number one? And how do we do it on the Bermuda requirement that it's reasonably required in the interest of the protection of public health? It's not, with the greatest respect, and I would say this is not what the Constitution embraces with respect, my lord, that the government is acting reasonably in implementing a policy if it just chooses to do what it chooses to do because it feels that it is best. That cannot be the measure of the test, in my view. It's got to be applied both legally, constitutionally, and then on a scientific basis. And if that science conflicts with other science, then that doesn't necessarily make it reasonable. It's something that has to be considered. And if they won't consider it with respect, then it's a matter for the courts to consider it, because there's nowhere else to go. It can't be just a question of the government could do whatever it wants. I mean, let's say that, and this is an example we've heard hue and cry about this, that the government took the position, and they've taken a very strong position on this, but the government took the position that if children under the age of 2, if their parents are unvaccinated, should be separated from their mothers and put into foster care or something, because in looking at it, the mother has a greater risk of contracting the virus than the children do. I mean, that would be something that, in my respectful view, we wouldn't just look at and say, we wouldn't just look at and say, oh, that's acceptable, that's reasonable. And if the government choose to take an action like that, obviously I'm being hyperbolic, but if they chose to take an action like that, then that would be something we would have to come. The only recourse would be constitutionally to go to the court and say, this is entirely unreasonable. So there are going to be those positions, and this is one we say, where it has to be for the court to look at it and say, is that reasonably required? If the court arrives at the position on the basis of all of it that it's reasonably required and that it's in the balance of interest, then so be it. But it certainly is a position that the court has to be able to review. My lord, number 22.
Yes.
Under the current regulations, the respondents permit a vaccinated COVID traveler who tests positive upon arrival to quarantine at home, irrespective of the vaccination status of other individuals who may reside with the traveler at that home. That with respect, irrational in my respectful submission. Whether or not a vaccinated traveler tests positive for one of the COVID-19 variants would not be discovered until after the individual was already at home, irrespective of whether they are unvaccinated residents residing at home. In those circumstances, the respondent would not require the resident to subsequently be quarantined in a government facility. I mean, that's where a degree of, it's not really commonsensical in those circumstances that would be the approach. At 24, my lord, conversely, an unvaccinated traveler who has received a negative pre-arrival COVID-19 test will nevertheless be subject to the mandatory 14-day quarantine, irrespective of the fact that they are perfectly able and willing to isolate and quarantine at home. And that is why, my lord, in addressing this, we have all those forms, we have those waivers. That's why they should contain a notice to say, big red letters, if you breach this, you will be subject to, a fine that is significantly punitive, coupled with imprisonment. I mean, we as the applicants are advocating that position. That's how law-abiding the applicants are. They want to ensure that anyone listening who is unvaccinated gets the message. The applicants do not want to have a position where just because people are unvaccinated, they think they don't have to abide by the rules and are, don't have to strictly adhere to the provisions of quarantine. The advocates are advocating that there needs to be and there should be strict measures in place with regard to fines, enforcement, tracking. We have the tracking devices on the phone now, my lords. There are the ability to have all these things checked. They are advocating that those measures should be strict and should be well enforced and well publicized. They just draw the line on don't make me go and pay to stay in a hotel. I want to be able to be healthy, comply, eat my own food at home, see my children and put them to bed in their rooms, which is healthy for them so they're not afraid, go outside and walk on my grass within my area, have the vitamin D on my porch, all of these things that don't and cannot happen if a person is in forced quarantine, that are healthy, that encourage immunity. And it's ironic to me that the government experts in being genuine in the greatest respect have not highlighted that element of things, that there are factors involved in home quarantine that are far more healthy for individuals and far more healthy in combating this disease by merely being in their own environment, psychologically more healthy, food-wise more healthy, just all of the things that are provisions for good health, for a person being in their own environment. And just because it's a hotel, who wants to stay, any room 12 by 12, my lord, is a confined space. It could be a hotel suite. You're told you got to stay there, for a period of 14 days and you can't go outside. Most right-thinking people, if you give that to them with free glasses of champagne, are not going to want to be placed in that position. They will say, I promise you, I will do whatever is required and I will stay at home. That is what the majority of right-thinking people will invariably, they will do that. My lord, at 25, the respondents have failed to establish that the protection of Bermuda's borders cannot be achieved by less intrusive means other than the discrimination of unvaccinated travelers. On this basis, the mandatory 14-day quarantine is irrational in its instance because it is disproportionate to any contribution which it could rationally be expected to make. We think that's borne out by the evidence. It's disproportionate. To your lordship's point, all the points that your lordship makes in that regard are valid, but it is a consideration for the court as to whether it is disproportionate. We say it's well established in law, my lord, and enunciating the authority of the Secretary of State and the Home Department that a measure may respond to a real problem, but nevertheless be irrational and disproportionate by reasons of it being discriminatory in some respect that is incapable of objective justification. as is here. My lord, I'm coming to the balance of interest position, which must be, with the greatest respect, a consideration for the court. At 27, my lord, the respondents have failed to provide any evidence that in coming to their decision to implement the mandatory hotel quarantine, they fully appreciated the importance of Section 11 of constitutional rights. And I have to say, it's striking to me that at no point with regard to that does it seem to be a consideration of constitutional rights as far as that position is taken. The respondents' evidence completely disregards the high cost of mandatory 14-day quarantine. The respondents have failed to provide any evidence of consideration of the financial burden that the measure will have on unvaccinated individuals. And my lord, that's where we say, in crossing the line and being unreasonable, this is a punitive measure. This is punitive.
Well,
it's not just the case.
The government used to pay, as you know, and they decided that they could no longer afford it.
Right. And one understands that. So you can't, therefore, so what's your other options? The other options are consider what's reasonable to have people quarantine at home, not say, because you have, for whatever reasons, taken the decision not to be vaccinated, that you have to pay for it. That is punitive. You're fining them for not being vaccinated. You are incarcerating them. I've termed it that way. It's a bit of hyperbole, but you are locked. But you are. I mean, incarceration is you force somebody to stay in a particular isolated place and they can't go. You're incarcerating them.
But I mean, you go back. It's not just discrimination on the basis of status. It's discrimination based upon risk profile.
Well, yeah, but then it becomes a question, my lord, as how does one reasonably address the risk profile?
No, I understand that. I mean, I understand.
Yeah, so that's the problem.
But it's not simply say that just because they're unvaccinated, they're being discriminated. It's only because they're unvaccinated, they have a different risk profile from the vaccinated ones.
My lord, I'll tag that on, and I will still make the point that it's punitive because they are unvaccinated and they have a higher risk profile.
Yes.
I think that would be the correct term to say. They're unvaccinated and they have a higher risk profile. Right? Again, it's odds. You're going in because you have a higher risk profile. And this is a subjective test as well, because let's look at it this way. Your 18-year-old healthy, fit individual who, let's say is an athlete or so on, probably has a significantly less chance, and this is on the science, of contracting COVID than your 75-year-old obese, hypertensive, diabetic individual. And the fact there's no assessment. I'm sorry?
I'm not sure there's any evidence in relation to that.
Well, maybe I've been watching too much BBC, my lord. But I mean, there might not be in regard to this. So, but I mean, we're not quarantining people under the age of 18. So, I mean, there's evidence of that. One would assume that we're doing that on the basis that they're deemed to be in the healthiest category going. That somehow you cross the threshold at 18. But that's a fact. Under the age of 18, you don't have to quarantine. When the government first came out with the policy, my lord, it was over the age of 65. For some reason, you didn't have to do it. And they resiled from that, and kept it at under 18 for whatever reason. They looked at that policy, but that has to just be sensible logic. That somebody who is at risk of being unhealthy may present a greater risk position in going into quarantine than somebody who is not, and that doesn't seem to be part of that assessment. So, my lord, I'm now addressing that balance of interests, which we seem to be saying to it at 27.
Yes.
Thank you. The respondents have failed to provide any evidence in their coming to the decision to implement the mandatory hotel quarantine. They fully appreciate the importance of the Section 11 of the Constitutional Rights. Sorry, I said that more. 28. The respondent's evidence completely disregards the high costs. I've said that. 29. The respondent's expert report acknowledges that evidence supporting mandatory quarantine at government facilities is limited. Moreover, the report acknowledges that the acceptability of enforcement measures varies across countries, with harsher measures more likely to be applied in authoritarian regimes and harsher measures more acceptable as a condition upon entry or re-entry to a country, as opposed to those who live and belong to that country. To your lordship's point a while ago, I think that, it becomes a sensible almost immigration permission that one has to embrace their own, and they're entitled to put them into a different category than people that are coming into your country. That's number one. And number two, you're certainly entitled to look at it sensibly with regard to where they are coming from. And if they're in a red zone, if they're in certain countries, and we have the provision here, then you're well entitled to look at that position differently. My lord, I with respect, I hate to do this, but could I beg a 3-minute adjournment?
Yes, of course.
Yeah, I'd be obliged. Just 3 minutes, my lord.
Yes. We'll
Thank you.
Stay here.
Thank you, my lord.
Yes, Mr. Pettingill.
Obliged, my lord. Thank you so much. Let's see, Mr. Duncan is back. My lord, could I please pick up at para 31 of our submission?
Yes.
My lord, in considering the expert's report, I think it is of note to make these points that the respondent's expert report highlights the reality that adherence to quarantine measures is affected inter alia by, these are just, this is what is going to happen with regard to people that have this forced quarantine position. They're going to have worries about financial impact, practical problems such as needing to obtain food and supplies relevant to them subjectively, I would say, my lord. And 3, emotional factors such as distress or boredom for the fact of being confined. And some of those people perhaps having to be confined with their children. And I pause there, my lord, to say, some would say perhaps, well, that's their choice because they're choosing not to be vaccinated. But with respect, what we say is that again should not be that harsh in the circumstances where, for whatever reasons, they are choosing to not be vaccinated. That is far too punitive, and that the cost and the damage of that is potentially far too high on any individual, on any normal, sane individual. Notwithstanding the concessions made in the respondent's expert's report, the respondents have still failed to address the matters which would, according to its own evidence, assist with the adherence to quarantine. In fact, the matters which the respondent's expert report says are relevant factors to ensure adherence to quarantine are inextricably inherent in the mandatory 14-day quarantine, as it causes worries about the financial impact, emotional distress, and practical problems, all of which could be alleviated and all of which can be ameliorated by less intrusive measures, accomplishing the same ends, but without compromising the legitimate public health interest. My lord, the balance of interest between the public health and the individual constitutional rights of a person, of the applicants, as to how they can be balanced. It is highly relevant, my lord, that if individuals refuse a mandatory 14-day hotel quarantine, they're liable to criminal sanctions. To my point, again, there is nothing wrong at all, the applicants would say, with regard to a mandatory quarantine at home that imposes stringent criminal sanctions in that regard, and the ability to make people aware of this is what will occur if you do not adhere to these provisions. My lord, all of the factors we would say point to the conclusion the respondents have underplayed the importance of the applicant's Section 11 constitutional rights, and mandatory hotel quarantine has a disproportionate effect with regard to what is the reasonable goal to be achieved. And regrettably, the only recourse that the applicants have to having that concern addressed is through the court to consider that position. My lord, in turning to the evidence at 35, the applicants rely upon the following affidavits, which I'll come to. There's the affidavit of Wendy Warren, of Aaron Evans, of Dr. Henry Dowling, and of Dr. Osser Ann. And we can come to those in due course, my lord. But certainly, I would say in summary that they present, in my view, an assessment, a significant position as to why there is not the scientific support for the position that mandatory paid quarantine of unvaccinated people is reasonably required in the circumstances, and that there are two considerations in that regard. One is the detrimental health impacts to individuals forced to do that, and the other is the ability to be fully compliant when being in a home environment, which is considered medically, and I don't think there's any dispute on this, and certainly my learned friends experts don't dispute this, that is considered to be more healthy to the individual. The real concern is them hopping the fence at night and going to a party, a valid concern. But I would say this, my lord, if there are strict positions in place for home quarantine, the type of person that is going to, in my view, breach that is the type of person that's going to make a sheet ladder and climb out of the hotel window or just leave in any event. Anybody who is prepared in the circumstances to breach the law is going to find a way. And putting them, short of putting them in Westgate, putting them in a hotel room is not going to ensure that position. You might say, well, it makes it potentially firmer because of whatever security measures are in place. I don't know, but I don't know what the positions are without them going out and walking around and so on. But the type of person that's prepared to breach that type of position is probably going to do it in any event because they're just not a law-abiding citizen. And those people exist across the board in a very small number, I would say, whether they're vaccinated or unvaccinated. There's just not science that's going to support this is the type of person that's going to do that. And just again, it is entirely offensive to say that just because a person is unvaccinated, they're more likely to be a breach risk than somebody who is. My lord, in turning to 35 on the applicable case law, and we have touched on this, the core thrust of the authorities are Mallet and the Philip Scottish Minister's case and the Secretary of State and the Home Department. But I say again, my lord, all of those cases, all of my learned friends' cases in support have to be read in the context of the Bermuda Constitution. So whilst there is reliance with regard to some of the substance of those authorities, one still has to, and the court, in my respectful view, has to fall back on the position of the wording and the import of the Bermuda Constitution. And regrettably, we don't have, as one would expect, other than this case developing, the case law that is going to prop up that position with regard to what is reasonably required. So we can only go so far with the considerations and the implementation of any of the authorities from overseas, because we have to put it in the subjective context, not only geographically of Bermuda and of our population.
Well, there is,
and the factors.
Mr.
I'm sorry?
Duncan has produced the Caribbean Constitutional Book, which does actually deal with this, the provision which we have in our Constitution.
In the Caribbean Constitution.
Yes, it's a authority, I think, sent yesterday.
Yes, my lord. Sorry.
Let me just ask you a point of principle.
Yes.
Cited these authorities, Bank Mallat, Philip, and Scottish ministers, and the Secretary of State. I mean, these are cases essentially of judicial review.
Yeah.
How does that marry up with the provision in our Constitution? The only issue here is as to whether these measures are reasonably required. I mean, the material which you have cited, which represents the English and the Scottish position in relation to judicial review proceedings, how is that relevant to us?
Well, my lord, with respect, I don't mean to be flippant saying this, but one has to go with what you've got. And as I've said, you're dealing with
concepts. They're different concepts. I mean, I'm just
true.
I mean, let's, for example, the measure has to be proportionate. I'm just trying to get your help as to, how does that conceptually apply to what I'm being asked to do under the Constitution as to whether the measures proposed or adopted are reasonably required in the interests of public health.
Yes, quite, my lord. Well, it is a consideration by those courts of the circumstances that are related to a similar type of imposition by the state on the individual. What I would say is this, my lord, that the constitutional position in interpreting the Bermuda Constitution, and I think this is the position that has to be seen in law, has to be a broader interpretive analysis with regard to the rights of the individual. So I think that the authorities can only assist in going so far in drawing some analysis and parallel with regard to the consideration of the court. But when it comes to a constitutional position, I think that the court has to consider that, and I've gone back to this a number of occasions. I keep coming back to reasonably required is a test specific to us, and that has to and should be given as broad an interpretation as possible with regard to the applicants and what the position with regard to the state is demanding of them.
And does it make any difference that the proposed legislation is proposed with the background of a pandemic?
Forgive me, Lord, that there was a beep and I missed you. Your Lordship said, does it make any difference
whether the measure which is proposed is reasonably required? What is the significance, if any, that we're in the middle of a pandemic?
Yes, I mean, of course, that is why the obviation of the right arises in the first place. It's the only way that it could arise, in my respectful view. One would be at pains to think of, other types of situations that relate to public health. One is immediately in considering the only thing that can obviate a constitutional right. It'd have to be something that was very significant and very serious. So we're at item on that basis. This is a serious thing. Just like if it was a measure related to national security, be a war or something like that. It's a very, very serious thing. That's the only way that they mount over that hurdle, as the ability to obviate the constitutional right. So you get there on that. The next question, in the words of the Constitution, in imposing such restrictions, so these are restrictions, and the government is having the right, because of the pandemic, to impose those restrictions. You then have to go down the line of what is reasonably required. And reasonably required in light of a pandemic. Reasonably required in light of a pandemic. And what we are saying by the evidence and by the case is that what is reasonably required does not need, in the circumstances, to go as far as forced mandatory quarantine of unvaccinated people, when there are other measures that can be equally as effective, largely and significantly equally as effective as taking that type of position. Does that answer your Lordship's question? I hope it does.
Yes, thank you.
Yeah, thank you. My Lord, if you bear with me for one moment, I'm just going to look at a position, if I may.
Yes, of course.
My Lord, if I could come to paragraph 38 at page 39, I'll pick up there.
Yes.
And this is dealing with the Mellick case. Would you say, my Lord, has application, if you will, in its application, of approach in addressing the issue of what is reasonably required, that this is the sensible approach, if you will, to be applied to constitutional provisions which obviate a constitutional right in circumstances such as a pandemic, and to what is reasonably required in those circumstances. So at 38, applying the 4-stage test in Mellick, The respondents were required in evidence in our submission, my lord, to prove inter alia.
You've got paragraph 238. Which one are you looking at? The first or the second?
I apologize, my lord. I should have had my 9-year-old do the accounting for me. I regret that. My lord, I'm on the first 38 of page 9.
Yes, okay.
Sorry, my lord, there was a degree of late editing. I missed these. So it's the and over the page, top of page 10.
Yes.
So the objective being pursued is sufficiently important to justify the limitation of a protected right. We're at item on that. 2, the mandatory hotel quarantine is rationally connected to the objective. 3, whether less intrusive measures could have been or could be used without unacceptably compromising the achievement of the objectives. And 3, whether balancing the severity of the measures effect on the rights of the persons to whom it applied against, the importance of the objective to the extent the measure would contribute to its achievement, the former outweighed the latter. And that is what we say is the consideration for your lordship. And that is why I have submitted the examples that I have and the analogies that I have, and also in an attempt to have a balancing act to your lordship's questions between what is really required, not essential, but required, reasonably required in the interest of a situation such as a pandemic. Nonetheless, as serious as that is, because of the constitutional consideration, it is still an important balancing act that has to be had. So, my lord, we respectfully submit with regard to the evidence that in both Mallet and Scottish ministers, the respondent parties have specified localized, relevant, contemporaneous, and updated factual evidence that was directly relevant to discharge their burden of proving the 4-stage test. With respect, the respondent's evidence does not come anywhere close to the requisite level, and the respondent's absence and poor quality of evidence acknowledges that ostensible concessions that they cannot, for whatever reasons, discharge their burden of proof, which is on them. By way of illustrated example of the nature, type, and quality of the evidence that is required to be produced in the context of these important constitutional challenges, the Scottish government relied upon a swath of evidence which was clearly dated and documented contemporaneously. The court nevertheless still ruled in favour of the petitioners, despite the respondents providing inter alia the Scottish government's harm and directives, a paper on the impact of COVID forces on transmission, 2, the report from the SAGE Environmental and Modelling Group, 3, the report from the Independent Science Pandemic and Modelling Group, 4, the Scottish government's paper titled Mitigation to Reduce Transmission of New Variants such as COVID-2 virus, 5, I'm over the page, my lord, the Scottish government internal memo, which were provided to the Scottish Cabinet Secretary outlining the options available for tightening the COVID-19 restrictions, internal emails, the decision to advisors set out detailed reasons for recommending implemented regulations, submissions by Director of Outbreak Management to the First Minister, and at 8, my lord, the Scottish government's paper entitled State of the Epidemic in Scotland. Why are those matters relevant?
Just on that, I mean, clearly, the Scottish government is quite a large institution. I mean, they have these reports and so on, and obviously, because they were relevant reports, they were duty bound to produce those reports and to the court. But there's no suggestion in that case, and I've read the Scottish minister's case, there's no suggestion that you must have these reports in order for the court to determine these issues.
No, not at all. And one thing, you must, it's not a question of that you must have them, but it does highlight the fact of when it comes to, and in this instance, I'll say, when one is going to consider obviating the constitutional rights of the individual, my respectful submission is you have to come with more than what you have come with.
No, but I mean,
and you have to very carefully.
The Scottish minister's case was exceptional and unusual. You obviously read the case, otherwise you wouldn't be citing it. I mean, you appreciate that. In fact, they held that the regulations were past the first 3 tests. They thought it was disproportionate simply because the government had outlawed people congregating in churches because they thought that the spread of COVID was extreme. But they had not outlawed the assembly of people in other places. And it was that fact which led to the judge concluding that this was disproportionate. I mean, obviously, because the judge didn't accept the explanation in relation to other exceptions where people were allowed to congregate and not allowed to congregate in a church. That was the real basis in that case. So I think factually, I'm not sure you can drive too much from that case. That case is actually quite helpful in terms of analysis of how the court should analyze the situation. And as I was putting to Mr. Griffiths QC, some of the propositions which they put forward are slightly different from the way you're putting forward. For example, they go as far as to say that the court has to be satisfied that the decision is clearly wrong.
Yes, and that's not obviously the case here, my lord, because again, what I'm saying is it has to be put in the context of our Constitution and the application of our Constitution. But I certainly think that there are
say that we have
fair.
to satisfy two aspects. One, the test which is set out in the English cases, starting with the Bank Malad case, and in addition, another layer of reasonable requirement under the Constitution. Is that your submission?
Yes. Yeah. 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 Exactly. I'm obliged, your lordship. That has to be the right position of the other layer. My lord, that might be at your direction. I note the time, a convenient point, and then I can pick up on the less intrusive measures and consider any of the other questions that I've noted that have been raised, if that's convenient.
So in that case, we will resume at 2:15. So I have some idea, and Mr. Duncan has. How long do you like it to be, Mr. Pettingham?
I would think that given where we're at on that right now, my lord, and considering obviously that there may be some reply, probably no more than another half hour.
Good. Well,
subject to any questions from your lordship.
Look forward to hearing from you further at 2:15.
I'm obliged, your lordship.
Thank you.
Thank you.